about that expedited tariff.
Yeah, we
Okay. Good morning, everyone. Today is December 3rd, 2024. This is an agenda meeting of the Minnesota Public Utilities Commission. Welcome to our agenda meeting. We have 5 items on our agenda for today. All commissioners are present for the hearing. I'll take the roll now. Good morning, Commissioner Means.
Here.
Commissioner Hom.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
And I'm Katie Sieben. A quorum is present. Our first item will be introduced by our Deputy Executive Secretary, Mike Bull. When you're ready, please introduce item number 1.
Thank you, Chair Sieben and Commissioners. Item number 1 is docket number 24-16, involving all utilities in the matter of Commission Subcommittee delegations under Minnesota Statutes 216A03, Subdivision 8. The question before the Commission is, should the Commission name Commissioner Kweekwan Hom Chair of the Subcommittee on Uncontested Proceedings? I have no further comments.
Commissioners, does anyone have any questions about the item? And before we move ahead, I'll call on you in a second, Commissioner Tuma. Commissioner Means, I want to take this opportunity to thank you for being the subcommittee chair for the previous however many years, or the chair of the subcommittee. So thank you for your service in that regard. I know it's a lot of work to review this.
Thank you, Madam Chair. When I was first requested to do this, it felt like professional hazing a little bit.
Have you been the one that hazed you into it?
You may have
I was
been.
going to say thank you for taking
may
on
have
the
been.
duty. I appreciated it.
Thank you for the kind words, Chair.
And Commissioner Hom, thank you for agreeing to do this. Commissioner Means, could you make a motion?
Certainly, I would move decision option 1.
Is there any discussion? All those in favor of appointing Commissioner Hom to chair the subcommittee on uncontested proceedings, please say aye.
Aye.
Opposed? The motion prevails. Thank you, Mr. Bull. The next item will be introduced by Caesar when he gets here or arrives. Is he not here? Is he online?
No, I think it's, I thought
Oh, Brett.
Brett is going to do it, yeah.
Our EFP supervisor, Mr. Eknes, welcome.
Good morning,
When
Chair
you're ready, take your time. Please introduce item number 2.
Okay. I will be pinch hitting for Mr. Panay today.
And I think you have to turn the mic on.
No, I was probably just in the mumble mode. Item number 2 involves Benton Solar LLC. It's in dockets GS-23-423, ESS-24-283, and TL-23-425. It's regarding the applications of Benton Solar LLC for site permits for a solar generating facility and a battery energy storage system and a route permit for the 115 kV transmission line. Questions for the Commission include, should the permit applications be found complete and reviewed under the alternative permitting process? What actions should the Commission take concerning the hearing process and other procedural matters? Should the Commission appoint an advisory task force? Should the Commission direct the Executive Secretary to issue an authorization to the applicant to initiate consultations with the State Historic Preservation Office, aka SHPO? And should the Commission approve LIUNA's November 6, 2024 petition to intervene as a party? Staff has one correction to the briefing paper. It is decision option 17, found on page 13 or 15 of 17 of the briefing paper. In that decision option, there's a mention of a certificate of need. There is no certificate of need in this proceeding. The decision option should read, require the applicant to place a copy of the route and site permit applications in the government center or public library located closest to the proposed project site. With that, staff is available for any questions the commission may have.
Okay, could the parties please come forward? And we'll take appearances first. Good morning. Starting on my right, please state your name and appearance for the record.
Good morning, Chair. Good morning, Commissioners. My name is Adam Gracia with NextEra Energy.
Morning, Chair Stephen, Commissioners. Micah Ravel on behalf of Benton Solar and NextEra Energy Resources.
Charles Sutton here on behalf of the International Union of Operating Engineers Local 49 and the North Central States Regional Council of Carpenters.
Chair, Commissioners, Kevin Pranis on behalf of Lyona, Minnesota, and North Dakota.
Okay, thank you. Mr. Ravel, first, the last time I talked to you, or the last time you were in front of the commission, we were talking about wind turbines. I assume that they're all moved now from what I saw in the paper, and I know it's not what we're here to talk about today, but it came to mind when I saw you. So any update on those wind turbines? Are they all gone?
Thank you, Madam Chair. I'm glad that I recall wind turbines to you, and I do believe that's correct. All of the wind turbines have been moved from the site from the Mara Wind Repower.
Good deal. Okay, just checking. I haven't been down that way. I bet, did you drive by lately, Commissioner
I
Tuma?
drive by. I wait for the parade, but they didn't give me a call. So.
Okay, so first we have this application in front of us, and what commissioner would like to begin with questions? Or are there were some late filed documents in here, starting with the applicant NextEra. Is there any update that you wanted to provide for the commission here this morning?
Thank you, Madam Chair. I'm not sure about the late filed documents, maybe just a letter not objecting to the intervention from Lyona. Yep. No further updates on that. We continue to have conversations with Mr. Pranis and with Lyona. And then late file document with respect to operating engineers and carpenters, and NextEra Benton Solar has no objection to the intervention petition of Local 49.
Okay, and Mr. Sutton, on behalf of the 49ers and the carpenters, can you let me know what you're requesting here too? Sorry, I'm a little behind the...
Thank you, Chair Stephen. Yeah, we filed some late an intervention petition. So essentially, I think in one of the decision options, I believe it's one of the decision options, 9, it says to grant Lyona's petition to intervene as a party in these dockets. And, I guess we would ask that we would also be granted our intervention to, or our petition to intervene as a party as well.
Okay, and thank you. It wasn't late, actually. I see it was October 18th. And Mr. Pranis, any update from you that you'd like to provide or comments before the commission takes up the...
Chair Stephen, Commission, I would be happy to review decision options and a suggested modification of a decision option. I don't think I have any other updates.
Sure, go ahead.
Thanks. So we like this resolved expeditiously this morning, and in general, in terms of the case, we support staff recommendations. The staff recommendations in general, 1, 3, 5, 6, 8, and 9. When it comes to the decision between 11 and 12 on a contested case, we would be comfortable with either, but we have modification proposal to 12 that I'll detail, and then we support 13 to 20 with a suggestion on number 16 that interveners be added to the list of those with whom the applicant is directed to cooperate in providing information. And then I can get into our specific modification for 12 and the reasoning.
Okay, go ahead. And commissioners, let us know if he's going too fast. Let me know.
So the goal is to build. I mean, just so folks understand what our view of this case is, we're expecting to build a record to support the need for additional protections to ensure compliance with new statutory requirements. And so that means obtaining evidence from the applicant and then providing information into the record. We believe that can be done through an informal proceeding or through a contested case proceeding, as long as the applicant is cooperative with that. And we had some challenges the last time we tried to do this with this applicant, but that was years ago. And hopefully we have new statutory requirements and hopefully clear direction from the commission. So for decision option 12, the modification we would suggest is clarifying. We appreciate the inclusion of the questions that we had filed in our first comments as part of the scope of discovery, but we would suggest that we add, instead of saying addressing the questions raised, we say addressing the proposed facilities, employment, and economic impacts in the vicinity of the facility site and throughout Minnesota, which is the statutory language from subpart 14, and then continue including the questions raised in Liona's October 31st, 2024 letter. And then after that, we would strike the last sentence. I'm not clear what's intended by the last sentence, but at least our experience of discovery and informal proceedings is that, I mean, discovery could begin relatively immediately. It might be concluded before the public hearing, since that's probably 180 days, give or take. It might, sometimes discovery continues after, depending on, you know, what questions are raised and some challenges. For example, we ask a question, the exact information isn't available. We have to modify that question to get that back and forth. So we don't see that last sentence as necessary. We think the normal discovery procedures that we use in informal proceedings should be fine. And I think that's, I would say the reasoning for this is we want to make sure that the scope should obviously be with the statutory requirements. We do think it's important for the commission to send a signal, though, of what it considers in the scope. We consider things that happen on other similar projects in adjacent states as potentially relevant to what we can expect out of this project. It would be helpful to have that clarified today rather than to kick that to the administrative law judge, because we don't want a Bitterroot situation where we have disputes over what is and isn't in scope, big picture, that just end up having to come back in front of the commission.
I think the challenge, Mr. Pranis, is like if we're not going to do like a normal contested case, then these like so-called normal discovery procedures don't always just like happen the way you've explained it, but we can keep discussing it to try to figure out a way, and maybe next era will be agreeable to answering some of these questions anyway, so it could happen in that regard. Commissioner Sullivan?
Thank you, Chair Sieben. I guess first I would appreciate if maybe we could put what Mr. Pranis said like into some red lines here so I could actually see what the decision option would look like. And then I would be interested, obviously, in what NextEra, what they think about that when we have it as proposed. So I don't know, Mr. Pranis, if you could distill.
Mr. Agnes.
Okay, yeah. Like probably just a couple.
Maybe we'll take a short break just to allow do you think we need a break, Mr. Eknes? Do you think we need a break to get yeah, okay. We'll take the commission will stand in recess until 10:20 a.m. from its recess, and it sounds like, did we get the language, Mr. Agnes, Mr. Graham? Great. So Commissioner Vice Chair Sullivan, you were saying, you wanted to hear from NextEra
Yeah.
perhaps on
Just
what,
want to hear,
first, this last sentence is X'd out, and is that, did someone propose that? You said that in your comments, Mr. Pranis? Okay. Mr. Ravel, what is the company's response to this new language?
Thank you, Chair Stephen. With respect to all staff's recommended decision options, just to put it out there, we agree with what staff has recommended, and so I think we can narrow the conversation to just this decision option 12. We are agreeable in large part to several changes here, including the insertion of the statutory language. We agree with that. We think that's a great change. Also, the striking of the time on the discovery, again, for a lot of the same reasons that Mr. Pranis said, we think that is also a good change. We similarly would propose a modification here, and it would be just striking the text that follows, including the questions raised in Liuna's October 31st letter. The reason for that is we think that the statute is sufficiently clear in what it directs the Commission to consider about the impacts of the facility, both in the immediate area around the facility and then the state at large. And so having that specific statutory language incorporated into the decision option for us guides the discovery process in a way that we find most helpful.
Tell me one more time what you're proposing to strike and why.
So we would strike the language, and the cursor's right there, that's highlighted in gray currently.
Because you're already going to answer those questions?
Well, we think that a lot of those questions are included in the statutory language, but we do have concerns about some of the breadth that's proposed in those questions.
Tell me why.
Sure. So there are a couple different concerns with what has been proposed. The first is they strike us as broad categories of information rather than specific requests, which I think is the intent. I don't think there's any confusion there. But we would expect that the specific requests would be more tailored. For instance, under the current language of the 4 categories in Liuna's reply comments, there could be an expectation for generation of new reports or analysis or product, and that's not the purview of discovery. So we don't want to set this project up for any additional requirement that other applicants aren't traditionally held to. So that's one concern. Some of the language is intentionally vague, which I think is on purpose to allow specific requests to get at certain information. And lastly, I think focusing the inquiry on Minnesota and the project-specific area is consistent with the statutory language. So drawing outside state examples, whether it's North Dakota or Wisconsin or Iowa, doesn't inform the question, the factor that the Commission is going to consider about the actual impacts, both locally and the greater state of Minnesota, as to the economic impact.
Mr. Ravel, it seems to me like this is like a lot of nuance to what you're raising concerns about, when my understanding of what Liuna was requesting, and I'm just looking back at the filing here, is a lot of it was based off of what is now required in statute. And so can you differentiate to me what you're willing to respond to that is not in statute, that you still think is fair for the Commission to consider so that we can assess the socioeconomic impacts of your proposal on the local economy and on the local workforce?
Chair Stephen, I think I can. I think I understand the question. So a lot of the information contained in the 4 categories that's requested by Liuna tracks the language of the statute specifically. Mm-hmm. And so for that information, we think that is exactly the type of information that we would anticipate providing in discovery. Where we have concerns is when we start venturing beyond the state boundaries, so other states, and that's both in the first and second category. And then there
The
are
first and second category, tell me what that is. Sorry, just because we're not all looking at the letter. When you say the first and second categories in Layuna's October 31st letter?
yes, that's what I mean.
And that is on page,
In,
what page?
Chair Stephen, in staff's briefing papers, it's on page 11,
Okay.
the bottom half.
And those categories are, as I'm pulling it up here, what? Related to the other states?
They're the four broad categories that Layuna has suggested be developed for the record. And we think a lot of that information is exactly what should be developed, but we do have concerns about language that steps beyond the boundaries of Minnesota. So based on the applicant's track record on renewable projects in Minnesota is completely fine with us, but when we go to other states, whether that's North Dakota or Wisconsin or Iowa, or California or New York, that's not what the statutory factor focuses on, and so
Right.
that's our concern there.
It just, and I see in question 1 and 2, it says Minnesota and other states. And your point is like, you'll talk about the impact on Minnesota, but not on other states?
Chair Stephen, that's correct.
But you will answer all 4 of these questions. You're not opposed as a blanket of, ruling, what's your track record with respect to local employment impacts in Minnesota and stuff like that. You can answer those questions, and you're willing to, is what I'm hearing you say. You just aren't going to comment on other states.
Chair Stephen, that's mostly correct, yes. I would also say that, and I think it's Layuna's position as well, that these aren't specific questions. They're rather the categories of discovery requests. And maybe Mr. Prentice can answer that. But I think viewing them as categories for record development rather than a specific discovery request, like these are the 4 questions we'll answer. There are other concerns that we have about what does a specific word mean, and do we have actual responsive material to the request. I think those are also concerns that we have. And so if we're viewing them as categories for developing the record rather than the specific requests, understanding there would be more detailed requests from Layuna later, we would be comfortable with that.
I think, we can spend a lot of time talking about what the specific words on the paper mean here, or we can move forward with your assurance that you're going to do your best to answer the questions that they ask, so that when it comes back to the commission, we have a full record and we're not getting into the weeds discussing what questions you refuse to answer. And then, it just makes it a lot harder for us, to be honest, if you're not willing to just provide the information that they're requesting. And I think that the statute directs us to gather now too. So I think I'm hearing that you're going to try to do your best to answer these types of questions. And we don't need to spend a lot of time parsing the details of what these words mean. Is that fair?
Chair Stephen, I think that's fair. We're going to use good faith efforts to provide the information that is consistent with what the commission is charged with evaluating and what the statute directs.
And Vice Chair Sullivan, I'll get to you in a second, but Mr. Prentice, help us understand what Mr. Revelle just said and what you think the commission should do with regard to helping get a full record so that we can make a good decision here when the application comes back in front of us.
Thank you, Chair Sieben, Commissioners. Certainly agree with Mr. Revelle that the purpose of those questions those are not discovery requests. Those are, to help assist with the scoping of discovery requests. And we think it's important because this is an issue that has not always been a part of contested case or other ALJ proceedings. And we've encountered problems in the past where the ALJs did not recognize the relevance of information the Commission did find relevant. It's important for the ALJ to get clear instruction on the scope that the commission has in mind in general, and then we would have specific requests that presumably the ALJ would process. I agree with your point, Chair, that someone has to adjudicate these things, and it raises the question of contested case. But I think what I hear Mr. Revelle saying, and I think what the company's been quite clear on, is that they do not intend that, I think as soon as we go to an ALJ, they will argue that, for example, the company's track record on similar projects in adjacent states is totally irrelevant to the question of what they'll do here. We agree that the question is the impacts on Minnesota, but information on the company's conduct in neighboring states and on other projects is entirely relevant, just as it would be relevant if the company were proposing a wind repower project near the city of Grand Meadow that said, look, we're going to need information on how often these repowering projects end up with blades stacked for 3 years. That would have been nice information to know if there had been information from Kansas or Missouri or Nebraska about that, right? Similarly, if there's, so it is absolutely relevant. A company's conduct nationally is absolutely potentially relevant to predicting the outcome. Now, again, if there's a clear plan that's locked in, if there are permit conditions that lock in a result, then we don't need to worry about other states. But we do need to worry in a context where the company retains full discretion over what it's going to do and how it's going to handle the project. And so we think that information is relevant. And I think the company's intent here is to avoid providing any of that information.
Vice Chair Sullivan, you had your hand up.
Your question really answered. I don't need to jump in and add my duplicative thoughts.
Okay. The other, my overall thoughts here are we can give a lot of direction to the ALJ and, have the ALJ prepare the findings and conclusions and recommendations that come in the public hearing. And, whether we need to make an explicit decision, like with regard to these questions, like I hope it will just kind of work itself out. And it's a little tricky, I'd say, but I think it's worth discussing here with the parties because, if it goes to the LJ and then you're fighting over what questions to answer and what not to answer, it's just going to make it that much more difficult for the commission to come back and make a decision, and it might not be a decision that people are happy with. So I'm not trying to sound like I'm lecturing, but like if you just agree to answer the questions and in general, like work with labor here, I think everyone will come to a better conclusion, including us, where it will be a little easier later when it comes back. But
No, you're right,
Commissioner Tuma?
Yeah, you're right, Madam Chair. I mean, it's going to self-govern itself. Yeah. Do LJs make bad decisions? Yeah, but we have to trust them. That's the way the system works. And if they make a bad decision, you have a right to come to us. I know this is difficult because it's the expedited process and we're trying to move permits ahead, but we have always been willing to answer questions that you think the ALJ has got wrong, and we've never done that. So I'm sure Mr. Revelle is aware of that, and so he's going to have to make decisions about whether to answer the question about what you did in South Dakota is worth the fight. Okay, and so that self-governs itself, I think, Madam Chair, and so I think we're fine with the language that Mr. Revelle has suggested. Just it's the statute and work with it, and if for some reason in the rules you don't get what you want, we're here. We hope we don't have to come here, I guess would be and that's the governing kind of principle that you guys got to work out. Trying to make a decision about maybe this going to happen is really hard at this point. Trying to make a decision, well, they might not do this. Well, we don't know that until they get in front of an ALJ. And I think it's my understanding in this process, the ALJ still mediates these, Mr. Revelle. If there is a dispute on a discovery or information request, I assume the ALJ mediates that. Is that correct?
That's my understanding
And so
But the expedited process, it's a little different too.
it is. Yeah,
It's
it
my
is.
understanding.
That's why I want to make sure that the ALJ would mediate that, and you would expect them to mediate that, and if they don't, I guess we need to send instructions down to the ALJ, and I have no problem saying that here, that, discovery suggests will be first mediated and decided by the ALJ. You wouldn't have a problem with putting that in there. And then there's a decision point that Mr. Prentice can bring here, so it just doesn't kind of fester out there, and then it all lands on our desk with a late filing the week before. So would you be okay with that kind of language being added, or? Mr. Prentice and Mr. Sutton I hear what you're saying, and we've been down this road before. I don't want to go there, but at least to get a decision point that you can bring to us if you have to.
Commissioner Tuma, Chair Sieben, Commissioners, certainly that's an option. It seems a suboptimal option. I think what you're hearing here today, we have been down this road, not just in general, but with this specific applicant on these specific kinds of questions where the applicant told us to go pound sand, metaphorically, when we asked these questions because it was none of our business. The ALJ didn't see it as our business. It would have ended up back in front of the commission, except that the project was pulled. The application was pulled because of interconnection issues. So and I think the applicant's been quite clear that they don't view some of the questions we think are important as legitimately within the scope. So there's no question that they're going to make that argument to the ALJ. There's no question we're going to ask those questions and make our arguments. The only question is whether the ALJ sort of sides with us on this relevance, or we're certifying it back to the commission, right? Or the commission could agree to our language, which I think would send the ALJ a pretty clear, these are things that, people are allowed to ask. Within that, the ALJ obviously has to manage it, but we can certainly proceed either way. I just anticipate the likelihood of this being certified back to the commission is quite high, given NextEra's current, sort of posture on these questions.
But Commissioner Tuma, I'm a little confused about your question, so let me just ask you, are you saying we do their new LIUNA, you do LIUNA 12 and but instead
of the gray highlighted line, add in the words, request that ALJ mediate and decide discovery questions. And the theory there is that they have to bring it to a decision point that they could bring back to us so it doesn't fester out there. That's the part that I'm worried. And the response to you, Mr. Prentice, is that, yeah, I get your letter lays out some pretty good framework that I have no problem with, but is it everything? I don't know. And I'm trying to make a predetermination on what are going to be maybe possible future disputes that may never be disputes puts us in a difficult position where we sit today. I don't have a problem making that decision if they dispute that down the road and we have a decision made by the ALJ saying, no, what they did in New Mexico is irrelevant and I will not allow it, and it comes to us, then we can assess that. But right now it's pretty general, kind of the letter you have. All the areas that I think are reasonable, but to us to make a decision on that is kind of hard. So
Commissioner Tuma, that's helpful, but Mr. Prentice, maybe I just missed it at the beginning, but what you still want us to do, the expedited process, just have essentially your decision option says do the expedited process, but do what you can to tell the judge that we want NextEra to answer our questions. Is that correct?
Chair Sieben, Commissioners, yes, that's correct. We're trying to accommodate. We would also be satisfied with a contested case, but we understand the desire to process these things timely. This may get worked out, through other means in between, and so we don't want to unduly delay the case. But I think we think that a clear signal from the Commission about the scope will help everyone understand what the expectations are, rather than leaving it to what feels like it might be a coin flip with the ALJ in a somewhat unusual proceeding.
Yeah. And do you think, and then I'll go to you, Commissioner Hum, do you think that the new language on your 12 is instructive enough? Because it does still reference the questions raised in your filing.
Chair Seaman, Commissioners, yes. To Commissioner Tuma's point, that's why we had proposed that it be including the questions. But in other words, the scope, obviously the scope is the statutory site, right? That's the scope of the inquiry. So there may be things outside the questions we asked that are relevant and that the ALJ would see as clearly relevant. We just thought there was a lot of value in staff having included our questions specifically, just to make clear to the ALJ, this is the kind of thing we're thinking about. Obviously, the details of that would be worked through by the ALJ. And we think that we don't see the only problem, I think, from the applicant's perspective with our proposed language is that there are certain information that they intend to oppose disclosing, that they have been quite clear with us and here that they intend to oppose disclosing, and they don't want that to be included. Because then it would be clear to the ALJ, yep, that's part of the inquiry that we're doing here. They want to sort of take their argument to the ALJ in the hopes of winning it there, which would likely bring us back in front of the commission if this doesn't otherwise get resolved.
But this is all, sorry everyone that I'm slow here today, but this is all like your concern is you want to be able to talk about the company's track record in other states, and the company is saying, no, that's not relevant. And so that's the one outstanding issue that seems to be the problem here, correct?
Chair Seaman, that's certainly the clearest. I am not still entirely clear on what all their objections are. I think the applicant is seeking to defer all of our legal arguments and objections to the ALJ and not air. The only one that's been aired here in front of the commission is about other states. And here again, the relevance, again, it's only to the degree that we can show relevance of the information on their conduct in other states, but clearly it's easy to imagine how conduct in other states might affect what we can expect out of this project.
Mr. Revelle, I'm like down a path and then back a different way, and now it's like you're not agreeing. I understand, like, you don't want to talk about what your relationship with labor in other states is, what it is my ear is hearing. And that's, maybe fair, maybe not fair for me to put it that bluntly, but that seems to be what the real rub here is. And so rather than like continuing to talk about it and figure it out, like, wouldn't a full contested case then just help, a judge could help decide whether what you do in the Dakotas is relevant or not, and then we don't have to keep arguing about it here? But you understand then, by you agreeing not to answer these questions or talk about your practices in other states, you're going to go through a longer process, and there's more, it's going to take longer. It's not going to be expedited. So what's your preference between the two? Either talk about your, the questions that Mr. Pranis is raising with regard to your track record in other states, or have a contested case and maybe the judge will order you to talk about it.
Yeah, thank you, Chair Stephen. All really good questions. A couple thoughts. One is the statute has changed since the time of the dispute that Mr. Pranis referenced on a prior project. And so I think baked into the statute is an understanding that applicants are going to be cooperative in providing information that allows the commission to analyze the economic impacts. So
but you just said earlier you didn't want to answer those questions about your practices in other states, and you filed your application after the new law passed. So, I mean, yeah, maybe it's not relevant from before, but like now we still have to talk about this some way or another.
So I think the relevance is what the statute focuses on, the economic impacts, the range of potential economic impacts for the specific area and the state of Minnesota. One concern that we have, and certainly a contested case is an option. I agree with many of the observations that would allow an ALJ some discretion to focus on this dispute. But one of the concerns here is if this issue comes up with this project, it's not going to be limited to just this project. And so if we're talking about alternative process, the expedited process, there's a real threat to slowing down a substantial amount of solar projects on these similar grounds if we're talking about looking at a lot of states outside of Minnesota. And so I think that's the other side of the coin that we're concerned with. It's not just don't look at what we're doing in other states. It's really an efficiency argument about okay, if we do want an expedited process, can we achieve that if we have to talk about multiple other jurisdictions and bring that in?
Commissioner Hahn, and then Commissioner Sullivan.
Thank you, Chair Steven. So what is your current queue position at the MISO on this project?
Thank you for the question, Commissioner Hom. You're asking for the actual queue number for the project?
The queue position of the what is the DPP year? Which year is it in?
This one was DPP 2020.
2020. So what stage of that is going on at the MISO?
We haven't executed GIA.
So you have do you have a off-taker on this project?
This project does not have an off-taker right now, Commissioner.
Okay. So without off-taker, you're not going to build it anyway, right?
Yes, that is correct, Commissioner.
Okay. So why do you prefer expedite process over the contested case, given this contested issue?
We would prefer the expedited process. We are in the process of negotiating an off-taker right now, so we are trying to do these things concurrently. So our hope is that we have secured an off-taker sooner rather than later, and then we can be on track to keep the project for COD at the end of year 2027.
Yeah, in my view, if there is any dispute during this process, whether we go contested case or the expedited process, if there is a unresolved dispute at the end of the day, we will prolong this process. So that's why I'm really surprised companies' unwillingness to work with other interveners on the data request. I think that's the minimum that applicant has to do as applicants. You have a burden of proof to prove your case, and then our statute requires certain labor issue, then you have to answer that. I think, to me, the question wasn't unreasonable to gauge whether you are doing good faith effort to do it. But when you are protesting that, I don't know whether you will get what you ask for expedite process, because it can prolong beyond what you're asking. So that's why I was asking you two questions, queue position and then off-taker issue.
Commissioner Sullivan.
I think we should just do a contested case. I have no, this is going to be precedent setting. Mr. Ravel said that this will be precedent setting. Shouldn't be a one-off. Therefore, we should have another set of eyes on it. I have heard that, this is in the gray zone where it's going to be difficult to tell the ALJ, to get the ALJ to rule on this. This alternative way forward. We have a tried and true process to move this ahead. Commissioner Ham's points there just reaffirmed it. I am ready to go with decision option 11. And I don't know if this was deliberations, but I can turn that into a question if anybody would like to respond to that. But I just think we should move ahead.
I hope not, because I have other questions, but let me try this, Commissioner Sullivan. We kind of maybe are in deliberations on this particular part of the issue. And I'm comfortable staying with the expedited process as laid out by Luna in 12, including the gray language. I would say including but not limited to questions raised in Leuna's October 31st, 2024 letter, and that any disputes regarding discovery will be mediated and decided by the ALJ. And to me, that we stay in the expedited process and we send a clear message to the ALJ that we don't want delay on these questions. We want, and Mr. Pranis and his folks will be able to make that point, that these are important, that we want to get this information, and if there is a dispute, it could come back to us for a decision. That way it can stay on the expedited track, and we hope that goodwill can work its way out in the expedited process. But it essentially turns into a contested case if you start disputing some of these decisions, because it's going to be coming back to us. And so I'd like to give it a try and stay within the expedited process, but yet create this environment. So I guess I'd ask that question. Do you want a contested case, or would you like kind of the TUMA modified LIUNA? And Mr. Pranis, I would ask.
Commissioner
first.
Tuma, you like coming up with new processes for,
Yes,
for
I do.
our,
This is right up my alley, Madam Chair,
different,
and I'm.
sometimes it works, I'll just remind you, and
Sometimes it
sometimes
doesn't
it doesn't. So I'm not convinced, but we'll hear
Mr.
more.
Pranis.
Chair, Commissioner Tuma, we agree. I mean, if we look forward on that process, we believe that it will be sufficient for the commission to send a clear signal as proposed there to the ALJ, to the applicant about here's the general scope. We don't expect to be unreasonable. There are things we might ask for that may not exist. There are things we might ask for that the ALJ will say, well, wait a minute, that's like clearly not in the scope. We think that's a reasonable way to proceed. We think a contested case is also reasonable, but again, wanting to have a timely way of processing these permits and believing that we can get the information we need without a contested case as well, that seems a reasonable option to us.
And, sorry to jump in, did you want to ask Mr. Sutton too?
Well, I would
What-
ask the other, just Sutton and the developer too, but you can go ahead.
I was just curious, Mr. Pranis, what you think about, though, what Mr. Revelle said about this is a precedent-setting project because it's the first of its kind since the law passed. Like, do you think, to Commissioner Sullivan's point, that that's worth sending to contested case so that the issue can be more fully developed? I'm not convinced that that one project is going to set some sort of precedent for other companies over how they're supposed to develop their labor standards, for example, or the economic impacts of a project. I don't think that's the way it's going to work, nor do we want it to as a commission. But what about that earlier exchange that Commissioner Sullivan had with Mr. Revelle about how this, these are big issues, though, and having a full contested case might be better.
Chair Sieben, Commissioners, we disagree with Mr. Revelle that this is precedent-setting in the sense that the Commission has already shown an interest in these issues, a willingness to, if needed, refer to contested case. The Commission has treated these issues seriously even before the statute changed. And so, like any other issue involved in a citing case, any number of parties may bring any number of different issues that might become important if we look back to Big Bend, and they can be disposed different ways. So Big Bend Wind, there was a contested case proceeding, if I remember correctly, the issue was resolved. But the point is, we don't know what issues will come up. They don't come up with each developer. There are multiple solar projects, as the Commission is aware, making their way through the informal process without the need for this. We don't see the need for this. I mean, just to be frank, the only reason we're here today is that we believed that we could take the developer at their word, and we tend to give everyone the benefit of the doubt. And that worked out very poorly for us in one case where we no longer believe that we can take NextEra at its kind of like general good faith word. I hope to get back to a place where we can, but that's why we don't know what the outcome of this project is, whereas in other projects are proceeding just fine using the informal process. So this is not precedent setting. Each case is different. Each case brings different facts. We think the Commission has two decent options to resolve this case, and we think the informal proceeding could work.
Nothing I've heard has changed my opinion. I think we have two strongly held positions here with the company, with labor, and I don't think that we're going to create an alternative process that is going to get us the record that we need. Ultimately, at the end of the day, we get to decide what's in that record. I mean, not what's in the record, but we get to weigh the evidence. So to the company's point, I don't see the problem. I mean, unless you want to keep something out of the record from our eyes, which I think is problematic. But we have contested case process, and we know that we're going to get the information. We know we'll get the full record. So unless the company comes around and says, yeah, we can deal with this, and we'll go there with the language, including the questions raised in Lyuna's October 31st letter, I mean, I kind of just want to be done with it. I've heard it. I understand what's going on, and I'm just ready, and I'm impatient, and I'm ready to go with the contested case.
I never get that way, so I appreciate that you are.
That is not true.
Boy, you're a truth teller today.
Commissioner Means.
the categories, the broad categories that you've outlined in the letter, to me.
Oh, your mic's not on. Sorry.
Need to say that again?
That's now, it's on.
The categories that you've outlined in your letter, in my opinion, are closely connected and appropriate to the issues that the commission will be considering. But it's clear to me that there will be objections to any questions presented under two of those categories as I see them. So why won't you just say that it makes more sense to do the contested case? Because I do agree with Commissioner Sullivan, because I think that defined process will better address all of the issues that the commission will ultimately be looking at.
Chair Seaman, Commissioner Means, we don't object to a contested case. Again, we'll make our argument with whatever, whatever is available to us. We wanted to avoid this coming back in front of the commission, and we see two paths to do that, but we don't object to a contested case.
Okay. Thank you. And Mr. Revelle, am I hearing correctly from you that there will be objections of some sort to any questions of any substance, really? Because the categories are broad, but of course there are going to be specific questions asked under those categories. And what I'm hearing you say is that you're going to object to most of those questions.
Madam Chair, Commissioner Means, in any discovery, I think it's safe to assume that there may be some objections, but right now we're talking in speculative terms. So it's the company's intent to cooperate in good faith, and we're not going to withhold all of the information. Like that's not the intent at all. But I think at this point, given the breadth of the categories, there's concern that some of them may venture into places where we don't have material or where we disagree about whether that is within the statutory charge for the commission to evaluate the impacts. So it's possible, yes.
And I appreciate that question. That's the appropriate question, the response you should give. But I'm also wondering whether you hear my colleagues and myself with respect to the expectation that you would be forthcoming to whatever information that you do have control over.
Mr. Means, yes, heard loud and clear.
Okay, thank you.
Madam Chair. I have another, this is totally off of what this is, so I'm done with this question of contested case, whatever we can deal with that when we get to deliberations. I had other questions, so if you're okay with going down that road, okay. Mr. Bell, I was looking at your schematics for this project, and I did notice that you did draw a circle around residential properties, very similar to what would be Benton County's setback requirements. 300 feet is what Benton County has. And I look at the permit here, and this is kind of the challenge I was having. There really is, no setback requirements or anything built into the permits. We obviously override local zoning. So I guess the first question I have to you, is it your intent essentially to follow substantially the setback requirements of Benton County in this particular situation?
Chair Seaman, Commissioner Duma, thank you for the question. Yes.
And it'd be nice, I guess, as you go forward in the discussions, in the hearings and that would be something you would look for language to insert into the permit of what that would be, how it would look, so that the citizens of Benton County can, see that, okay, they're going to follow Benton County's is fine. But if you're not, where you're not, and so that they can kind of see what those, requirements are for this permit. Because there are a few houses, I counted about 4, that are kind of in that 300-foot zone. And so I guess it would be nice to know that it's built into the permit. Yes, permittee, they're going to be 300 feet back. Is that your understanding? You're willing to do that?
Yes, Commissioner.
That's helpful because I think, like I said, there are a few pieces of property here that I just looking at the maps that are going to possibly be disputes. Maybe they're not. Maybe you've worked it out with them, and that would be my hope. But I think it's appropriate that we develop in the permits because it's a little different than wind. With solar, it'd be nice to have some language in there saying, this is what we're following for this project, and we've talked about it through the public hearings. So I appreciate that, Madam Chair. That's it.
Thank you, Chair Stephen. So one more question to the company. So when did you sign the GIA, and when is the your time limit under the GIA to have this in service?
Chair Stephen, Commissioner On, the GIA was signed in 2022, and our latest COD is end of year 2028.
Okay.
Our current plan is to COD in 2027, but we can extend the GIA out until the end of year 2028.
Okay. So even if we go into the contest case, you have enough time.
That's correct.
Are we ready? I think maybe we should take a short break before we move to deliberations. And, pardon?
To let the parties talk or something?
No, to consult with staff. But before we do that, are there any other questions for the parties? And Mr. Sutton, we didn't never hear from you, I don't think. Are you and the unions that you represent comfortable if we do a full contested case?
Thank you, Chair Stephen. Yeah, I don't think we have a perspective on the procedural decisions in front of the commission.
Okay. Let's just take a short break then, and we'll come back for deliberations. Commission stands in recess until 11:10. we'll come back from our recess. And Mr. Graham, could you please put up the language that Ms. Gretz helped me draft here? And the idea here is, commissioners, that if we're going to do, well, and it sounds like we're headed towards a full contested case, I think it would be beneficial if the commission now just decides that NextEra's labor practices in other states are relevant to the statutory criteria that should be applied in the matter. And then it will just be something that is developed in the record and comes back to us. And so if we're going to head this route, I think we should put this language in now. So I guess I don't really care if the applicants like it or not, but I care more if you like it, other commissioners, because I think that we heard Mr. Revelle say they don't want to talk about what happens in other states, and then they weren't willing to do it in a proceeding that would have been more expedited. So now it's like we're going the full contested case route, and I don't want the judge ruling that somehow the other states their past labor practices aren't relevant, and then it would have to come back to us to decide if it is or not relevant. So why not just decide it now that we care about this issue? And I think it would be helpful when we look at the new statutory criteria too, to just have it developed in the record. So that was kind of my thinking. If Commissioner Tuma, you have a question about it, or?
I just want to comment that I would support it. I mean, typically when we do this, if any commissioner feels that it's valuable, and if you feel this is valuable, let's gain that information. A little premature. I think it needs to be developed a little bit more, but I think the message is a clear message to send. And if you find that valuable, we should collect that information. I think that's always been the precedent. When I first came here, I remember, Bev Heidinger saying, if that's important information to you, we collect it. And it's definitely within the purview. And we're not asking them to tell us, what color their seats are in their corporate suite in Florida. We're asking them a relevant question to what is in front of us. So I think this is perfectly fine.
Commissioner Hum.
Thank you, Chair Stephen. I agree with the Commissioner Tuma. It's a relevant information in my view. And also, I think narrowing down this scope will help company to expedite this whole process too. Even though it goes to the contest case, now we are going to very narrow number of interveners and narrow topic that can help overall if it goes into the contest case.
Okay. Should we move into deliberations then, or do commissioners have other questions on other parts of the record?
Thank you.
Commissioner Hahn.
Thank you, Chair Stephen. In that case, can we see the modified language number 9 to reflect the 49ers intervention?
Good.
And then number 16, I think there was a suggestion that we make sure that interveners are also part of this discovery, and company should respond properly to the interveners. So number 16 language.
After the word by, just put in interveners.
And then I think, do we need, Ms. Gretz, that additional language? That was up to 16 where we have the ALJ prepare findings, conclusions, and recommendations? Or no, that was in the, is that going to happen under this?
If you go contested case.
It's not your fault. So this is fine, the language here. We don't need that additional language that we were talking about. Okay. Commissioner Hum, did you want to make a motion?
Can I just make a quick point? Something that I'm frustrated about here, it's clear. Based on my previous comments, I'm frustrated. But one of the things that I find really annoying about this is that we're going to chew up a lot of time here, and this could have been on the consent agenda. And I think that just needs to sink in.
Well, and
So-
to that point, Commissioner Sullivan, like in the past, we've had projects come before us where the commission spends a whole lot of time, and our staff spends time, and the department spends tons of time. And then if these issues aren't resolved, the projects don't happen either in some cases. And so like, I am not trying to be like a jerk, but we need some help here, Mr. Revelle from NextEra, in like understanding that this is not only important to the commission, but it's important to the state. And the statutory directive is pretty clear. So like, work it out, and then we'll all be friends and move forward with great projects. And it's just like,
I agree.
I appreciate your point, because it is like, this could have been resolved ahead of time, and we wouldn't even have to be doing this. It could have been on the consent agenda.
Yeah, and I think like this is, the truth of the matter is, if we don't work it out beforehand, we have a process for that. I think everybody needs to understand that. If we don't work it out, we have a process.
And it takes longer.
And it takes longer.
Yeah.
And that's kind of like, we went through this whole thing with permitting reform last year. But we'll have a process if people don't work it out.
Commissioner Hom, do you have a motion?
Yes, thank you, Chair Stephen. I'll move decision option number 1, 3, 5, 6, 8, number 9 as modified, 11A,
And 11.
and then 11, okay. And 13 through 20 with the modification for 16 and 17.
Did you say, sorry, what was after 16, Commissioner Hom?
So-
16 through 20?
13 through 20 with the modification to 16 and modification to 17 as presented in the screen.
Okay. Is there any discussion from commissioners on the motion? All in favor of Commissioner Hom's motion, please say aye.
Aye.
Opposed? The motion prevails. Thank you very much, everyone.
That was an easy one.
Oh, yeah. I don't know what I have here, so. Just in the interest of time. Ms. Marcus, when you're ready, please introduce item number 3 for us.
Good morning, Chair and Commissioners. Item number 3 involves CenterPoint Energy Minnesota Gas, docket G008 GR 23173, in the matter of the petition by CenterPoint Energy Minnesota Gas for the authority to increase natural gas rates in Minnesota. The question before the Commission is, should CenterPoint's 2025 interim rate request be approved? A revised decision option and an alternative decision option was filed yesterday. Copies are available in the front of the room. Parties are prepared to discuss preferred decision options, and staff and parties are available for questions.
Thank you very much, Ms. Marcus. We'll begin with the company. Please state your appearances, and then you can proceed with your opening comments.
Good morning, Chair Sieben and Commissioner Emily Supis with CenterPoint Energy.
Good morning, Jason Luce of CenterPoint Energy.
And good morning, Eric Swanson from Winthrop and Weinstein on behalf of CenterPoint Energy. And I can be very brief, I think, in our comments. You have before you, obviously, a very unique situation. This is the first time we've actually gotten to a hearing on a year 2 interim rate request in a multi-year rate plan. It's also the first time you will end up seeing an all parties, all issues settlement in a multi-year rate plan. So we're very proud of that, very thankful to the parties working cooperatively to get that done. So your decision is now informed by that settlement, although it isn't before you today. And in these unique circumstances, I'll let CUB and the OAG speak to their proposed decision option, but we see that as the reasonable and cleanest way forward at this point. We did have some concern as to whether we could implement their recommendation of going ahead and recognizing the settlement apportionment, but we confirmed that we can, so we're supportive.
You confirmed with who? With
internally at the company.
Okay.
That we can actually implement that recommendation, so we're supportive of it.
And then the other decision options I could just look at, and
yeah,
I'm sorry, I wasn't like jiving totally on 1A as a replacement for 1.
1A would be a replacement for 1, and then decision option 7, recognizing the January 1st implementation date.
You mean 6?
6.
Yeah.
Thank you, Commissioner.
Okay, and
So that was
next,
1 and 6, right?
1A and 6.
1A and 6, okay.
Mr. Schultz, did you want to go next? Could you please state your appearance and then provide any comments you'd like?
Thank you, Madam Chair. Good morning, Commissioners. Peter Schultz with the Office of the Attorney General, Residential Utilities Division. The OAG supports options 1A and 6. As you know, 1A was filed last night by CUB. We developed it with them. And it would simply authorize CenterPoint to increase their interim rates to match the final level agreed to in the settlement, while also requiring the interclass apportionment match the apportionment that the parties agreed to in that settlement. And that's shown in Attachment B to the settlement. And I want to be clear that the OAG cannot support a second interim rate increase unless the Commission uses that apportionment that was settled. And there's an important reason for that. The settlement moderates the increases for the residential and small business classes, and the difference between an across-the-board increase, which is what we would normally do in interim rates, and the settlement apportion is significant for these classes. For example, and you don't have to look at it now, but I'll just tell you that the apportionment in Attachment B for residents would result in a cumulative increase of about $40.5 million over the full 2-year period. And by contrast, if the Commission increased rates across the board as the company initially proposed for 2025, residents would see an increase of $65.3 million, which is almost $15 million more than under the settlement. Since the settlement's apportionment changes the existing rate design, implementing it as an interim rate increase requires finding exigent circumstances. And we believe there's a basis for that in this case based on the unique circumstances of an MYRP and the settlement the parties have reached. All parties to the case agree that CenterPoint has established the need for more revenue beginning in January 2025. That's less than a month from now. The parties have also agreed that moderating the final increases for residential and small business customers is in the public interest. And actually, based on the settlement and what the increase that was agreed to for 2024, residential customers are already overpaying interim rates now. And so approving a 2025 increase in line with the cumulative increase under the settlement for that class would actually provide immediate rate relief. And since final rates will likely not be approved until or implemented until well into 2025, that provides a further, reason for finding exigent circumstances and just matching. Simply, I think it's clean to just match 2025 interim rates to the settlement amounts until final rates go into effect. And of course, that's still subject to refund if the commission were to make changes. We don't support changes, but that is, of course, always the case. And so, to avoid harming residential and small business customers, we support the commission adopting 1A. And I'm available for questions.
And 6?
And 6, yes.
Thank you. Ms. Campbell.
Nancy Campbell.
Sorry. Ms. Campbell, usually I let you go last, so can we let Mr. Edstrom go? I apologize. Mr. Edstrom, welcome, and please state your name and provide any comments you'd like.
Thank you, Chair Sieben, and good morning, Commissioners. Brian Edstrom with the Citizens Utility Board of Minnesota. And yeah, thanks. I think I can largely just say ditto to what Mr. Schultz said. The language that we developed in 1A is intended to account for the kind of unusual circumstances of the 2025 interim rate request being filed before the settlement that is now filed. And that settlement, contains stipulated agreements about revenue apportionment that I think it just makes more logical sense to match interim rates to what those stipulated terms are under the settlement now. And doing so would help protect residential ratepayers from paying a higher interim rate in 2025 than I think would be necessary once the commission is able to review the settlement agreement. So I'm available to, we support 1A and 6 as well. Thank you.
Ms. Campbell, or did you have a clarification?
No, I have a question. I'm sorry, I forgot that we were not done. Yeah.
Ms. Campbell, welcome. Please state your appearance.
Nancy Campbell for the Department of Commerce. In light of the all parties, all issues settlement that was filed on November 25th, we now support decision options 1A and decision options 6. We agree that'll help get rates to customers, especially residential customers, charged more closely with the settlement for at least for 2025 purposes. And I think it'll keep it consistent with interim rate requirements as well. So that's why we selected 1A and 6. Thank you.
Thank you. Commissioner Sullivan.
Thank you. Thank you, Chair Sieben. I think it's, in general, I'm kind of like the outcome that people are at. What my question is like, I need some more thinking or some more explanation around the factual basis for how we can use exigent circumstances this way. And I know the OAG, you have said you wouldn't support it, but for, using exigent circumstances like as identified in 1A. So maybe we can start with you, but I would just like to hear from the parties, like, I don't think of exigent circumstances this way. I think the statute as implemented has been pretty clear, but I'll let you convince me.
Sure, Madam Chair,
Schultz.
Commissioner Sullivan. Yeah, I think probably foremost in the commissioner's minds is the sort of findings of exigent circumstances during the global pandemic when there were rate cases, and there were clearly a global pandemic's an exigency, but the commission has found used exigent circumstances in other situations that are much less what you'd think of as an emergency. One common one is when typically it's a gas utility wants to exempt price-sensitive large customers, like market rate or flex rate customers, from an interim increase. And as long as they eat the foregone revenue, they're allowed to, basically that's a change to the rate design because they're giving a class a break. And has been done based on a finding of exigent circumstances in at least in many MERC rate cases, Great Plains rate cases. And then also I know that in Dakota Electric's last rate case, and I think in a prior rate case, that company asked to recover 50% of the interim rate increase it was entitled to under the statute. So that wasn't a rate design change, but it basically asked for half of the revenue it was entitled to under the statute. And that was done based on a finding of exigent circumstances. So the Commission's done it in a number of different situations.
Commissioner Sullivan.
I'd like to hear from Mr. Swanson. Yeah.
Thank you, Madam Chair, Commissioner Sullivan. And I think it's important to think about this in a couple different ways because of the uniqueness of this situation. First, we now have, at least from the party's perspective, an agreement as to what is a reasonable revenue requirement for 2025. That doesn't require any finding of exigent circumstances. What requires the finding of exigent circumstances is the change to existing rate design. And in this case, you have an applicant that has agreed that residential customers should see a significantly lower increase than they would if we just followed the formula. That's a really odd situation, an unusual situation. It also benefits the CNI-A class as well. And lest you think...
so basically, let me just boil that down for just a second. Basically, the rates are not just and reasonable as they sit right now.
We have stipulated to that now.
And therefore, that is the motivating... That's the motivation behind the use of exigent circumstances.
Exactly, Madam Chair, Commissioner Sullivan. And unless you think that somehow this is in any way generous to the company, I'd also point out that because we're agreeing with this, CenterPoint is one of those that always gets a finding of exigent circumstances to not pass interim rates onto our market rate customers. By agreeing to the stipulated rate design, the company's actually going to eat more revenue in 2025. But we think it's a reasonable and rational result because we've already agreed that that is the appropriate rate design.
Mr. Edstrom, Ms. Campbell, I just kind of want to crowdsource this, so I really...
Yeah, thank you, Commissioner Sullivan. I think just to add to that, I think by my lawyer math, which others should correct me if I'm wrong, Ms. Campbell, I'm looking at you. I think if the 2025 interim rates were approved under the normal formulaic process, residential customers would end up paying about $24.8 million more than is stipulated under the settlement. That's accounting for 2024 interim rates as well. So I think that, going to your just and reasonable question, is a fact that I think supports a finding of exigent circumstances.
Ms. Campbell,
I think this is kind of an unusual situation by filing this settlement when we did and having this kind of big change in the rate design for residential customers. And honestly, we're just trying to get it so that it better matches the settlement and to not overcharge residential customers unnecessarily and then require refunds at the end of it. So it just is a common sense, makes more sense to do it this way, and we're hoping that exigent circumstances can be applied to allow us to do so.
It's just weird because the settlement isn't in front of us either. And so you're all doing these acrobatics to make us approve what probably is contingent on us approving the settlement. And so there's a little bit of unease I have just by finding exigent circumstances for something that you think will happen later. It's a little odd. I agree that the timing is not ideal, but it might be just the way things go here. But Commissioner Tuma?
Yeah, Madam Chair, obviously when this came in front of us, I was looking for a solution, and as I was digesting my turkey, I'm glad you guys have conferred on this because I wasn't happy with us just doing interim rates, so I was very confused by the filings. But that's what's bothering me now, is that I don't have much of a record in front of me. I have assurances that it is, and the department is, but I haven't seen a lot of the math here. We're doing math, lawyer math at the table, so if I'm going to find exigent circumstances, I would want to have more in front of me, but I'm concerned. Obviously, the timing is a problem, and that's why I was trying to solve the problem by just saying let's deal with this all when we get to the settlement and just jigger up the math. And if there's something you're owed, we'll do a surcharge. If there's not something you're owed, you take it out of the refund that's to be paid. So I just want to explore that. That was my thought. Let's just wait till the settlement. We'll let you start collecting. Use this exact language that you've come up with here. Let you start collecting from an accounting standpoint, okay? But let's settle it all out with a spreadsheet, and our staff gets to look at it, the department gets to look at it. And yeah, there might be a little surcharge, there might be less of a refund, but at least we see the math, okay? So why not do it that way? I mean, I'm hearing because the residential ratepayers are going to immediately see some recovery of $24-some million or whatever it is. Help me out. Why wouldn't we do let's see the math first?
Madam Chair, Commissioner Tuma, a couple reasons, I think. First, as CUB and OAG have said, following this route provides relief to residential and CNIA customers beginning January 1, 2025, rather than waiting.
And I have to take your word on that because I don't see that in the record right now. People talk about settlement, and I've seen the settlement, but there's not a lot of discussion of what the settlement means. So I would be taking your word on that.
Madam Chair, Commissioner Tuma, with all due respect, no, I don't think so, because you can compare the revenue increase in attachment B to the settlement with the revenue increase that would have been apportioned under the interim rate petition, and you can see the difference. So the numbers are there in the record already showing exactly what Mr. Schultz and Mr. Edstrom have talked about.
So that's your assurance. The residential people are going to see less rates on January 1. Because that was my problem, is that I don't want a rate increase on January 1 in the middle of the heating season, and that when people are looking at it, I didn't want that.
Mr. Swanson, just let him finish, please, so we're not all
No,
talking
that's
over
okay.
each
I
other.
mean, I just want to make
it's not
absolutely sure.
okay. I like it better when one person's talking at a time, so we can hear.
About that, Madam Chair.
Yeah.
I apologize. Madam Chair, Commissioner Tuma, to be clear, no, there would be an increase January 1, 2025. It will be significantly less to the residential class under Alternative 1A than it would have been under what the company requested.
So let's walk through that. I want to understand this now, because what I suggested is everything stays status quo until the settlement shows up. So when I get my bill, I don't get yours, I get the one from the XL, but let's say I'm a CenterPoint. I get the bill on January 1, and what I'm suggesting, nothing changes. I don't see any change. Won't see any change until the settlement and final rates are put into place, and there'll be either a surcharge or a refund. Okay? Now, that's what I'm trying to suggest, and we deal with the math then. What I'm hearing is that on January 1, there's going to be an increase, but it's going to be less because we implement this amount. So I'll actually get a notice saying your rates just went up thanks to the PUC on January 1st in the middle of the heating season, but it's less than. That's what the ratepayer is going to see.
Madam Chair, Commissioner Tuma, it won't say that, but to be clear, yes, there would be a rate increase beginning January 1 to match the agreed upon revenues. If you're looking for a different solution that keeps the company whole to what the parties have all agreed to, then I think you'd have to approve deferred accounting. Also, if you want the company to just track, you need to approve deferred accounting because under the statute, we can't go back to January 1 when you determine, oh, you're right, the settlement is approved now or it's modified, whatever. We can't go back to January 1. Under your proposal, you would have denied interim rates completely, so you have to set up a deferred accounting mechanism. Otherwise,
That was my intent when I say.
otherwise the company's
account
not
for but
whole.
It's mentioning account for but not collect.
Right.
Is what I was trying to say.
And I think from the party's perspective, this is just the simpler way to do it than do the math on the back end and have some sort of temporary surcharge. We'd have to figure out when it was going to be collected. There would be other compliance filings. This seems like the more elegant solution.
I'll work with that. I'll ask these guys this, but let me just make sure I'm clear then. So on January 1, rates will go up, but not as much as they would have been if we would have done interim rates.
Madam Chair, Commissioner Tuma, correct.
And there'll be a notice out there. People will see that.
Correct.
And just to track with you, there is a rate refund owed to residential ratepayers, and that would be collected and determined after final rates are put into place.
Madam Chair, Commissioner Tuma, I think you have a couple options on that. You're correct that under the standard course, it would just be figured out at the end and then refunded them. But you could also require the company to do a compliance filing earlier that shows the amount of the refund that is owed for 2024, and the company could process it during this heating season still.
So we could actually today come up with a decision option to say, do it quicker, but that's presupposing the agreement of settlement. We would have to put a language in there, subject to our later decision on the settlement, and you would be okay with that.
Madam Chair, Commissioner Tuma,
So
we
how
would.
soon would you be able to do that?
Madam Chair, Commissioner Tuma, we had a feeling that question might be asked, and we're comfortable that we can make our pledge to take all good faith efforts to get the refunds going out by March 1. Because we have to close the books on 2024 first and figure out what that refund looks like. But we think we can implement beginning March 1.
So if we were to take a break, how long would it take you to figure out the right language for us so that these three people to your right can say that that's okay, or have they said it's okay already?
Mr. Swanson.
Madam Chair, Commissioner Tuma, I don't know, but I don't expect there's opposition to a quicker refund.
Yeah, so that would be interesting to me. So to my, Madam Chair, if it's okay, to my friends over to the right of Mr. Swanson, you heard my concern, and I just want to make sure we're tracking. I kind of like this alternative, and maybe it gets a little bit towards what I was trying to accomplish, but not completely, because our ratepayers are going to see, I got a rate increase, but it's not going to be as much as we thought it was going to be. I can see how that's going to read. I know how it's going to read. So, but you're okay with that?
Mr. Schultz.
Sorry, okay, Madam Chair, okay with
the plan to go ahead, and there is going to be a rate increase. I was hearing rate savings, and that's not what I was hearing the first time you guys went through this. I was hearing rate savings, not a rate increase.
Madam
Mr.
Chair,
Schultz.
Commissioner Tuma, so if you look at attachment B, the cumulative increase over the 2 years for the residential class is about 40 million, and under the way they proposed, so that'll actually, and they're paying more than that under 2024 interim rates right now, and so it's a lower revenue requirement cumulatively under the settlement than it is in 2020, just in 2024 for residents. Now, maybe there's an increase because of the impact of decoupling or something like that, but under the proposal that we have submitted, the revenue requirement, the increase in 2025 should be lower, absent the impact of decoupling or something else. That's our read of it.
I take your word on that, but when they get the bill on January 1, you agree that it's going to say the PUC is now allowed us to increase your rates by 0.00 whatever. That's what it's going to say, the bill that's going out to the ratepayers, right?
Mr. Schultz.
Madam Chair, Commissioner Tuma, I guess I don't know for sure what the bill is going to say, and I can't confirm what the company said about there being a rate increase. I guess they would know better than us probably, but our read is that the revenue requirement is lower.
Which is good. I mean, when we get to the settlement debate, I'm going to probably agree with you. We're not there yet. I just want to know the practical effects of what was happening. I was trying to avoid that by putting the decision out at a later date and letting the numbers play themselves out then and keep everybody status quo.
Mr. Schultz.
Madam Chair, Commissioner Tuma, yes, and status quo is that residents are paying too much compared to what the settlement says they should be paying.
That's persuasive to me, but I'm still hearing that when I get the bill, I'm going to see rate went up. Mr. Swanson, people rushing up, trying to help you out, so.
Just.
Madam Chair, Commissioner Tuma, I was focused on the big picture. I have been corrected, and Mr. Schultz is correct, that the residential class, so once we break it down by class, the residential class is currently seeing about a 14.4% increase. And
because of interim rates.
Under the stipulated revenue apportionment, if you approve 1A, that will go down.
And so when I get my bill, I'm just going to be very clear, very, very simple. I get my bill, it'll say, the PUC has made a determination, and now your rates are going to go down slightly because of this interim rate decision.
No.
Madam,
Mr. Swanson.
Madam Chair, Commissioner Tuma, the residential class will see a lower interim rate charge on their bill than they are currently seeing if you approve 1A.
It'll go down.
Other classes will see more.
That's all right. I mean, I'm a resident. I'm not a business, so that's why I was putting myself as a resident. That's who I was focusing on. I probably should have been clear on that. As a residential ratepayer, I will see a statement saying it has gone down.
Mr. Swanson.
Madam Chair, Commissioner Tuma, we haven't talked about what kind of customer notice would be. But
I know. I'm just, but in general, you know what I'm saying. I mean,
yes, that's the practical, real-world impact. Yes.
And do you agree with that, Mr. Edstrom and Ms. Campbell? I just want to make sure we're tracking, because that's not what the record told me. That's what's the frustrating part about this, is the record didn't tell me that, and the settlement didn't. That's the part. Why wasn't this in the settlement? I mean, this would have made our lives a whole lot easier.
Well, the settlement isn't in front of us.
Well, I know, but if they would have dealt with the settlement, if they would have put it in the interim rate, there's going to be settled this way, and there'll be a pre-hearing on that issue, not confirming that that's going to be the final rates, but just this is how the interim rate should be handled, our life would have been a lot easier. But I'm hearing it now, you've agreed to this. This is, in a sense, to you, an extension of the settlement. And you're okay with it, and you agree that it's going to actually be less for the residential ratepayers.
Mr. Edstrom.
Commissioner Tuma, thanks. Yes, and I appreciate your concerns and what the clarification you're seeking. Yes, it was my understanding, consistent with how Mr. Schultz described it, that the revenue apportionment for the residential class specifically would be slightly lower if you approve 1A, as it is now under the 2024 interim rates that were previously approved.
Would you support a earlier, kind of an extension of the settlement, an earlier disposition of temporarily subject to change of the interim refund?
Mr. Edstrom.
Commissioner Tuma, yes.
And then I would hope that if we could take a break, could you come up with some language with that as something you could do with working with the company?
Mr. Edstrom.
Commissioner Tuma, yes.
It would also be nice that that language also includes some sort of compliance filing on notice, so we know notice approval by the executive secretary, so what we can see the notice, and you can do that before January 1 notice language that's going to go in the January 1 bill. If we have it, even though the order might not come out, whatever, that's something you can do.
Mr. Swanson.
Madam Chair, Commissioner Tuma, we believe we can, yes.
We typically have that language, it's just not here, so that would be standard language that Ms. Tom looks at it and says it looks good, so, and then Will signs off it and we're all good. Madam Chair, those are all the questions I have. I guess I would like to see some language at some point to accomplish those last 2 points. So we might need to take a break at some point.
Do Commissioner Sullivan?
Thank you, Chair Sieben. Now the one thing that I'm wondering, it's an all-party settlement that you have developed, right? So all customer classes represented, so large users, everybody.
Madam Chair, Commissioner Sullivan, the parties to the case are the parties you have before you, and then SRA, the 49ers, and LIUNA.
But not the large, not
There was
Mr.
no-
Maratska's, they were not involved.
Madam Chair, Commissioner Sullivan, there was no intervention.
Okay. Now, that answers the question. So all of the parties that were involved, obviously, that makes sense. Now, the one thing that I'm wondering about is, I know it's an all-party settlement. I generally like all-party settlements. I want to, but there, since this is unusual and it is coming in an order that is not normal, that does kind of box the commission. I'm wondering, it feels to me like the commission could be starting to get itself boxed in a little bit. If the that wouldn't change the way that I would rule, or I would decide in that vote in that decision. But if the all parties settlement were rejected by the commission, what is the recourse around this decision? Like, then we have interim rates that are in effect under an all-party settlement that was rejected. We have an allocations and class cost of service study that has been rejected. What happens?
Mr. Swanson.
Madam Chair, Commissioner Sullivan, people like Mr. Demerit and Ms. Campbell would have a lot of work to do, but we can always do math on the back end to conform to a commission settlement or a commission decision. It would just be messy. But I have every confidence that whatever your final order is, the parties will be able to work cooperatively and implement. We obviously hope it's approval of the settlement, but if it's not, we'll work together in that way. Or
Ms.
we'll
Campbell.
go back to contested case hearing.
Ms. Campbell? I'm just asking this because I haven't seen the settlement. I don't know anything about it other than that it exists.
Right. I would like to think this commission would approve an all parties, all issues settlement.
Well,
I don't
we have
think
trouble
we've
sometimes with
seen
things,
something different than that. But obviously, if you do, it's my understanding that people have to talk about whether, they can agree with that change as a group, or otherwise we have to go back and address that issue, and contest a case. So I agree with what the company stated. So, but
the question was, you could do the math to undo certain portions that the commission didn't agree with. I mean,
I feel like
I appreciate the casualness of like, oh, this is an all-party settlement, and so you have to accept it, but that's not the reality. Like, the commission still needs to, in deciding just and reasonable rates, needs to look at what you bring to us and decide whether every increase that you think is a good idea, whether we agree with it. And so the question to Commissioner Sullivan's answer is, like, if we wouldn't agree to it, even though you think we should, we could still do the math to undo that portion or change it, regardless of the decision we make here today on interim rates, correct?
Yes, I feel like we can always do the math. It's just how complicated it is. The concern that I had when with like the revised 2, though, is for interim rates, you can refund.
What is decision option 2?
No, Commissioner Tuma's revised 2. The concern I have with that is for interim rates, you can refund, but you can't surcharge under the requirements. So you would have to do deferred accounting or something very unusual. So that's why, most of the parties preferred 1A. It's a lot cleaner and simpler to implement.
I passed it, so don't worry.
So, but
And
yes, I think
our-
we can do that.
Our staff, and I don't I guess we need to take a break at some point, but said that decision 1A, according to the math that Mr. Alonso was doing, would give the CenterPoint increase would be 103.4 million, not 101.9 million. And that difference between the two is $1.5 million. So, Mr. Swanson, the commission can approve 1A, but we still, to the Commissioner Tuma's point earlier, like there still needs to be some math done to decide if that's what it would be, and do those numbers sound right to you?
Madam Chair, yes, those numbers sound right.
And that difference of $1.5 million, the company just eats that essentially? Or what happens with them? Are customers overcharged the $1.5 million, or
No,
is it the customers are overcharged that?
Madam Chair, you approve 1A for setting the final revenue increase equal to the settlement, which is the
Where's that $1.5 million go then? You collect it then, and you get to keep it. And then maybe that could be brought up in this settlement, or we could, if anyone, I don't know. The numbers don't match up exactly, so I'm just trying to, we usually argue over a lot less money than $1.5 million, so I'm looking to you, Commissioner Tuma. I guess we could just like bring it up when we take up the settlement somehow. Or
Yeah, it will be brought up at that time, but I think you're right. The money would be collected and would go to the company as an interim rate increase. And so the money is then now collected, and that whole problem of eating money that was not, dealt with in the rate case, like we had MP. Remember, we had that kind of problem with MP because there was this, lag in time, and so that problem would not we wouldn't have to worry about that. But rates are increasing. That's the point. So.
Okay, Mr. Swanson.
Nothing for now, Madam Chair.
I guess our staff, we need a break before we do anything too, it sounds like. So, commissioners, do you want to take a longer break for lunch and then come back in a half hour or 40 minutes?
And Madam Chair, what I would like to see from the parties is language regarding a compliance filing on the numbers, so that we have a compliance filing with the actual numbers. If we approve 1A, that we have a compliance filing on notice on January 1, and then language that would allow us to do an earlier, subject to our final approval later, but an earlier dispersion of the interim refund. So if you could do that, then our life becomes a lot easier when we come back.
Okay, so the commission will stand in recess. Ms. Marcus, is there anything else you need before a break, or no? Okay, the commission stands in recess until 12:45, hopefully. the commission will come back from its recess, and who would like to go? Mr. Swanson, I understand you might have something to say.
We do. Thank you, Madam Chair and Commissioners. The parties had a chance to discuss several things over the break and have language addressing, we think, every issue that we heard brought up. But if we miss something, obviously let us know. First and foremost, to resolve what was a question out there as to the meaning of decision option 1A, while the parties all believe you could approve 1A to avoid any concerns and to move us quickly toward resolution, we hope the company agrees to a modified 1A that would go back to the $33.2 million.
Where's that? Do you have the language?
Yes, and we sent some to staff. They'll pull it up. So there's the new 1A after the red there. Find exigent circumstances and authorize, I did shorthand, CPE to implement a 2025 interim rate increase equal to $101.94 million. That was the number from the briefing papers. But then using the revenue apportionment stipulated to an attachment B. Then that seemed the simplest way to resolve any concerns between the numbers, and the company's comfortable with that. On the Commissioner Tuma's concern, I'll go down before I go back up. Commissioner Tuma's concern about seeing the math is the last paragraph there. The company will make a compliance filing by December 19, 2024, detailing the class-by-class 2025 interim rate increases to take effect January 1, 2025, compared to the 2024 class-by-class interim rate increases. That's where you'll see that the residential class actually will have lower rates, lower interim rates in 2025 than they currently have. And conversely, of course, you'll see other classes having higher interim rates.
Commissioner Tuma?
I would just say probably just rate impact as opposed to increases of one's going down some, but that's more semantics. I get what you're saying.
Then on the customer notices, rather than making an early filing and getting comments, we thought it might be the simplest to just direct us to work with parties and staff to develop customer notices reflecting the commission decision regarding 2025 interim rates and file the agreed upon notices by the end of the year. And the company will provide a compliance filing by January 31, 2025, detailing the proposed refund of 2024 interim rates, subject to modification in the event the commission modifies the settlement, and will implement the refund beginning with bills issued March 1, 2025, so that customers see some heating season relief.
Question?
We're all happy to take any questions.
Do any of the parties oppose any of this language? I assume not. Commissioners, do you have other questions? Then Commissioner Sullivan, will you make a motion?
I'd be happy to. So my motion will be decision option 1A as modified by CenterPoint and the parties. Then I would move decision option 6.
So that's all the language on the screen, essentially, right?
Yeah, you kind of have 1A.
Because we kind of, 1A is above, and we
Yes.
we'll just, yeah.
Yeah. Okay. Okay, there. Okay, yep. Got it. Okay.
New 1A.
Yep, the new 1A.
Is there any discussion of Commissioner Sullivan's motion? All those in favor, please say aye.
Aye.
Opposed? The motion prevails. Thank you very much, everyone.
Thank you, Commissioners.
Our last, oh no, we have 2 more dockets,
Same,
right?
yeah, same matter, but 2
Okay.
dockets.
Please introduce our next docket, Mr. Bonnet.
Good afternoon, Chair Sieben, Commissioners. Agenda item number 4 is docket number G022/GR-24-350 in the matter of the application of Greater Minnesota Gas for authority to increase rates for natural gas utility service in Minnesota. The issues in front of the Commission today are, should this filing be accepted? If so, should the proposed rates be suspended? The matter referred to the Office of Administrative Hearings and interim rates set as requested by the company. The company filed 2 documents late yesterday. One was information that the department requested in their comments, and the other was a response to the staff briefing papers. Commissioners received those documents, and there are hard copies in the back of the room should anybody else need some. The parties are available for opening comments, and staff is available to answer any questions. Thank you.
Thank you. Okay, if the parties could come forward, we'll get started here. So, Mr. Swanson, please state your appearance, and then you or Ms. Anderson, whoever would like to begin, go ahead.
Thank you, Madam Chair and Commissioners. Eric Swanson with Winthrop and Weinstein on behalf of Greater Minnesota Gas, and also with me is Christine Anderson, Corporate Attorney. Thank you very much, Madam Chair. I wanted, because Greater Minnesota Gas has been away from the Commission for a rate case for 15 years now, I wanted to take just a minute or two to reacquaint you with the company. They're a comparatively new company. They'll be celebrating their 30th anniversary next year as a company. And this year is their 20th year. It took them 10 years to grow big enough to even come under Commission jurisdiction. The majority of their plant has been put in service in the last 20 years. And they were founded and still operate under a pretty simple mission: provide clean, safe, affordable natural gas service to customers in areas predominantly that have been unserved in the past. I think there are a number of unique things about Greater Minnesota that you'll learn as this case moves forward. There is a real culture of responsiveness there. There are 25 total employees in Greater Minnesota Gas. So, for example, when we provide information on our top 10 paid, that's 40% of our work staff. It's a little different. We have a total of 11,000 customers. So about 1/100th the size of the utilities you more often deal with here, or the utility that I just spoke to you about. Because of that, we really tried to make this a very simple case. The last case that the company filed was back in 2009, as I mentioned. The company at that time only asked for 60% of their revenue requirement increase that they showed as being required, because they were concerned about rate shock. Again, it's the culture of responsiveness and care to the customers. I can give you one quick factoid on that, demonstrating, when a customer calls Greater Minnesota Gas, they actually talk to a person. That's a rather novel concept these days, but they actually get a person. And we checked through the service quality reports, and in the last 5 years, either the Attorney General's office or your CAO has received one complaint from a customer. And it was a customer who had been disconnected and didn't want us to do the safety check before reconnecting them. And when we explained, we did the safety check and they got reconnected. That's it. So I think they've done a good job of being responsive to their customers. It also means that we're really trying to do a rate case with as little expense passed through to customers as possible. $50,000 in regulatory fees doesn't sound like a lot for the companies you typically deal with. For us, it's almost $5 a customer. That's a lot. So we have no problem with this case being moved on to OAH, but we certainly hope that we can find something similar to the 2009 case where we went to OAH, but then we followed an informal process. The department did a thorough investigation, filed comments, agreed that the company wasn't even asking for what it could. The company agreed with the department's comments, and we were done. We hope we can see something similar to that this time around, because it'll be better for our customers, frankly. One other factoid that I can't help but mention, again, just demonstrating the proportionality here. The entire rate increase request for Greater Minnesota Gas is less than the rate case expenses asked for by the major utilities in the state. So we hope we're willing to be as open a book as we can be as this process moves forward, and we hope that we can work cooperatively and come to you down the road with a reasonable resolution of this case. But that's all I have for now. And I'll be happy to answer questions, as will Ms. Anderson.
Okay, thank you. And next, the department.
Good morning, Madam Chair, Commissioners. Craig Adonisio for the Department of Commerce. I just have a few topics I want to discuss very briefly, and then I'll run through decision options. Starting with completeness, as staff mentioned, the company made a filing late yesterday that addressed all of the completeness issues that we had identified in our comments. So we can recommend that the Commission find the filing complete as of November 1st without qualification now. With respect to schedule, we do recommend that the Commission add the 90 extra days allowed by statute based on other pending rate cases. The way we had this mapped out internally, we budgeted about a little under 11 months for this rate case. And so those extra 2 months would be added on to the period between the ALJ's report and the Commission's final order. So it would really just kind of give the Commission the extra flexibility. If it needs the time, it has it. If it doesn't, it can bring this to an agenda meeting earlier than that. On that same note, with respect to the informal process, the department is very open to some kind of informal process as we used in the 2009 rate case. I just have one minor concern about kind of how strenuously we advocate for that in the Commission's order here, if we include any language. And that just relates to the fact that, as Mr. Swanson mentioned, in the 09 rate case, they were only asking for 60% of their revenue deficiency. That leaves a lot of room for us to not agree on issues and still not have any impact on final rates. We don't have that cushion in this rate case. They're asking for their full revenue deficiency. So I just want to make sure that whatever process we follow, we establish a good enough record for the Commission to make informed decisions if it comes back to you. And so that's my only concern with that. But like I said, we are very open, and we recognize the company's concerns about managing rate case expenses and how that's unique relative to our other IOUs. And then finally, on interim rates, as I mentioned in our November 12th completeness comments, our only concern about the company's interim rate proposal was the ability to track and calculate, to track interim rate revenue and then calculate refunds at the end, which is a part that the Commission or the department, will be involved in. I understand from briefing papers and another filing in the docket that staff and the company had talked about that, and the company assured staff that under their original interim rate proposal, they could do all the necessary calculations accurately. So that's good enough for me. There was a new interim rate proposal in yesterday's filings. I don't know which one is kind of the most on the table, and from the company's perspective, I think we're kind of indifferent between the two. And I think that's everything. I'll just run through our preferred decision alternatives quickly. We recommend decision option number 1, number 5, number 7, number 9, number 10, all of number 10, number 12, and then we don't take a position on any of the remaining decision options.
Including the late filing? You don't take a position on the, oh, sorry, I didn't fully read the filing that came in yesterday, so I'm not sure what's happening, and Mr. Swanson didn't address it, so we can ask him. But you said earlier you're indifferent about the late filing or the interim rate increase?
Madam Chair, that's correct. The interim rate, there were 2 filings yesterday. We are indifferent about the interim rate filing yesterday versus what was in the initial filing.
Okay. Thank you. And Mr. Cherney from the OAG, please state your appearance and then provide any comments you'd like.
Madam Chair, Commissioners, good afternoon. Joey Cherney with the Office of the Attorney General Residential Utilities Division. I'll start by noting that we didn't comment on completeness or interim rates. I'm going to limit my remarks just to referral or suspension of rates and referral. We do recommend suspending rates and referring to the Office of Administrative Hearings. We absolutely recognize the need to, or the desire to keep regulatory costs down. This is also, it is a rate case, and the way to properly review the rate case is to go to the Office of Administrative Hearings. So we're committed to working as efficiently as possible with the company. We appreciate that they're an open book, as Mr. Swanson said, while still ensuring that rates are just and reasonable. And in particular, you know, it's been a very long time since it's been 15 years since their last rate case. A lot can change in 15 years. You know, they have a 15-year-old return on equity. They have a 15-year-old rate design, 15-year-old cost allocation. So those are the things that are of particular interest to us. But as I said, we're committed to keeping regulatory costs low and completing the review in a timely manner. So our preferred decision options, again, limited to what we commented on, are 5, 7, and 9. Thank you.
Okay, and Mr. Swanson, can you now address the late filing or Ms. Anderson and what you're proposing we do under interim rates?
Sure. I'll defer to Ms. Anderson on that.
Thank you, Madam Chair, Commissioners. Christine Anderson from Greater Minnesota Gas. As Mr. Adonisio indicated, the department's primary concern was whether the company would be able to accurately track the interim rates such that it would be easily identifiable for any compliance filings and for refund purposes in the event a refund is necessary. And we would have been able to do that even the way we originally proposed it. We recognize that our original proposal was somewhat different from what the commission normally sees. We still feel that it does comply with interim rate requirements, but our rate proposal has 2 components. One is an increase to the facility fee, which is our customer charge, and one is an increase to the distribution charge. And both of those are roughly 15% when you round them. We did adjust by a few pennies here or there in the rounding to make the numbers nice and even on the customer charges, because that just is a common sense thing when a customer is looking at a bill to see something that ends in 50 cents rather than 52 cents or things like that, right? But roughly 15%. We proposed for interim rates exactly what our proposed rate schedule is, exactly what our proposed rates are going to be, because we don't have anything in our proposed rate base that are the kinds of things that typically get carved out for interim rates. Our rate case is really, truly bare bones based on what our increase costs are. We don't have prospective projects that won't happen if rates aren't approved. We haven't proposed adding a lot of staff. Yes, we'd like to go from 25 to 26, but we need to go from 25 to 26 anyway. And that will happen whether the rate increase is approved or not, more than likely. So we don't have those typical carve-outs. We did recognize when the briefing papers came out right before Thanksgiving that staff seemed concerned about whether our changes constitute a change to rate design because it was essentially hard numbers instead of a percentage, which is what the commission usually sees. So what we filed yesterday with respect to the briefing paper response is essentially a slightly different proposal for interim rates that more closely resembles what the commission and the other parties involved in the case are used to seeing. So it recommends a percentage increase that would be the same across customer classes, 15% increase in the facility fee, 15% increase in the distribution charge. So as a practical matter, the numbers are still pretty close to what we proposed, but by doing it as a flat percentage across all customer classes, we feel like that will hopefully address any of the concerns that staff indicated or any concerns that commissioners might have about whether hard numbers might constitute a change in rate design. We have still identified it as two separate line items. We recognize that most utilities just do 1% based on non-gas revenue, and they total the amount of their customer charges and the amount of their distribution charges, and then they have a flat percentage that's applied to that. We've opted not to do that, so our customers would see two interim line items. They'd see all their normal billing line items, and then they would see interim facility fee adjustment, which would be the 15% change to the facility fee. And then they would see the interim distribution charge adjustment, and that would be the 15% charge to the distribution. The reason that we've opted to do it that way is because we think that that is more appropriate for our customer base, particularly some of our larger seasonal users, and we think it reduces the risk of refunds because it more closely resembles what we're asking for. In theory, right, or as a practical matter, even I can do this as lawyer math. If you total the customer charge and the distribution charge and you take 15% of it, that's going to be the same amount at just that 15% level if you take 15% of the facility fee and 15% of the distribution charge, right? Those two numbers are going to be the same. 15% of $10 is $1.50. 15% of a $2 customer charge and an $8 distribution charge still gets you to $1.50. But where the difference comes in is in that volumetric. When customers are actually paying an increased distribution charge, that gets paid on all of their volume usage. By splitting this out, they're only paying the increased distribution percentage on their actual volumetric use. They're still only paying the 15% charge on the facility fee. So what will happen is for some of our larger users in, say, our asphalt companies in the summer or our grain drying customers in the fall, when they have very high usage, they'll only be paying the increase, the interim increase that's associated with the distribution charge. They won't also be paying a volumetric portion of increase on the facility fee. So we think it makes more sense. We also think it will impact residential customers less in the event that we have a cold winter, which we may. All the gas companies that come before you sort of hope so. We don't really like warm winters. We like gas meters to spin. But the same principle applies, right? If a customer is paying an increased charge all around that's based on a volumetric, it's going to necessarily be more in the end than if they're only paying the change to the facility fee on the facility fee line, and then the change to the distribution charge on the volumetric. So we feel that what we proposed yesterday strikes a balance between the concerns that staff identified and that the department kind of hinted at in its comments, and it still allows for easy tracking. It allows for easy identification on the bills.
Okay, thanks, Ms. Anderson. Commissioners, who wants to begin with questions? Commissioner Tuma.
Why don't you hand out Jason handout to the commissioners and the staff. I was totally confused by Table 1 of the DOC's comments, and my brain started spinning around in circles. Could have been the too much turkey. It could have been
Too much time
extra,
on your hands.
yeah, extra gravy. Too much time on my hands after my kidney stone surgery on Wednesday, and so I was trying to get my brain around what you were proposing, and when I looked at Table 1, Mr. Addonizio, it would seem to me that would have violated the interim rate statute where it says it shall include no changes to existing rate design. And I saw a lot of rate design change when I looked at this with this chart. So that's what confused me. I heard the words in there saying, well, it's roughly the same, which is not what the statute says. It says that if it's roughly the same. So I saw a lot of numbers moving around, and I might not have disagreed with it because I looked like ag was going to pay 25% increase in the interim rates. And so that's Table 1, DOC Table 1, and then you see everybody's slightly different. Residential ratepayers of 15.5, but then, large service 13.33, and so help me out. What were you seeing, or where did this come from? It looks like to me that's a rate design change. Is that what you were trying to indicate, or am I just missing it?
Mr. Addonizio.
Madam Chair, Commissioner Tuma, I think the answer is yes. So looking at my Table 1, I calculated the percentage increase for each facility fee and each distribution charge.
Based on the raw number they gave you.
Exactly. And if every single one of those numbers was 15.00%, every one of those increases, then that would produce the same effect as what we normally do for interim rates, where we come up with one single percentage that then gets multiplied by the non-fuel base rate charges. I am going to be very careful to not take a position on whether the variation from the 15.00% that I showed here, I don't have a strong opinion of whether that constitutes a prohibited.
The result looks good. I like the result in some ways too, but the result is not, me liking the result is not an exigent circumstance. So I guess that was what I'm struggling with. We just had you suffered through what we just had to go through to get to exigent circumstances. It doesn't seem to me, it would seem to me if we were to go with the Table 1 original proposal, I think we would have to find, you don't have to have an opinion on it, I would think we'd have to find exigent circumstances. But you're taking no position, and we're talking $1.4 million. We're not going to have a heartburn over it, as I think what the department is saying.
Madam Chair, Commissioner Tuma, I'm trying to say even less than that.
Yeah.
But yes.
Yeah, so that's what I was trying to understand. Go ahead, Commissioner Sullivan, if you have questions. I got more to go, but.
I just have a real high-level question on this point, which is like, I don't understand what's so complicated here. Like, we have an interim rate statute that says, basically, take the new costs, load them up into the old formula, go. Doesn't seem hard. Like, I mean, I'm not like being accusatory. Mr. Addonizio looking at you, but like, I don't know why we have Miss Anderson too. Like, it feels really easy to me. Like, none of this stuff can change. It just, the new costs can be loaded up into the old formula, and then we'll argue about the old formula for the next year. And then that's a rate case. Am I wrong? I think your thumb's up.
I was pointing, are you asking me?
Yeah.
Madam Chair, Commissioner Sullivan, I think if that's I largely agree with that point of view. This is simple. I think the company's proposal yesterday matches exactly what you seem to be getting at.
So the new proposal in front of us today matches exactly what I just said.
Yeah, I
Okay.
think nothing is as clear as you want it to be when you get down into the details, but yes, I think.
Okay.
And that was the next question
Thank
I
you.
had, Madam Chair. And I'm looking at the bottom chart now, okay? And we were trying, and they were doing this, I guess this morning, probably, trying to make sure our numbers were correct. And so we think this is what you were recommending, and what the numbers in gray would be the actual calculations that would be in ratepayers' bills that would amount to 15% across the board. And so, is our staff trying to reverse engineer this in short order? Is that substantially accurate? I mean, it could be some mistakes there, but is that they were trying to accomplish what you recommended, which wasn't very clear to me when I read it, Ms. Anderson. It kind of sounded like we're sticking with our own numbers, but we're going to do 15%. So it was confusing to me. So I just want to make sure this is what you're proposing now, is that bottom chart, 15% across the board with these numbers. Is that right?
Ms. Anderson?
Madam Chair, Commissioner Tuma, yes, that's correct.
And then where the middle one is where we thought we were trying to accomplish, like we would do for most other rate cases, which you said, and I kind of buy your argument, that in this situation that we maybe should do a percentage increase for both, okay? And so staff tried to come up with what that would look like to get to the $1.4 million of what would be your rate case amount, or your interim rate amount. And so they came up with this number, and the math just doesn't seem to add up to me when I have a 0 and a 14.86, and the other one's 15 and 15. So where are we wrong here? Or I just want to make sure that the bottom one gets me to 1.4 and not substantially more than 1.4.
Madam Chair, Commissioner Tuma, I think the difference comes in what the totals look like, right? So I used the example earlier of if you do 15% of $10, right, that's $1.50. So if we used that sort of hypothetical on the staff calculation, it would be 0 and 15%. If you were looking at a $10 total, you'd have $1.50. If you took that $10 and you said $2 of it is facility fee and $8 of it is distribution charge, and you do 15% of $2, you get 30 cents, 15% of $8, you get $1.20, you still get $1.50. But where the difference comes in is in how customers are paying that. Because let's say that it's the volumetric is 100, right? So at the 0 and 15%, they're paying 100 times $1.50, so $15. But with our proposal, with the two line items, they're paying 30 cents for the increase on the facility fee, right? 15% of the $2 facility fee. So they're paying an additional 30 cents. They're paying 100 times the volumetric increase of $1.20. So that's $12. So they're paying $12.30 versus $15, right? It comes out in how the volumetric works. That's a very basic way to show it, but I think that's why you have the numbers difference. It's a little bit different number if you're using the 0 and under your staff calculations 14.86 than if you're using 15 and 15%. But that's why. It's because the 15% on the facility fee change is only charged once. The 15% on the volumetric is charged based on customer usage.
And so, just so I'm very clear then, on the bottom one, which is your proposal, it's still going to raise roughly $1.4 million in interim rates.
Roughly, yes.
And so we can rely on that. That's what your statement is today. And if it's different, then we'll have to deal with it down the road. But I just wanted to make sure when we adopt your proposal today, it's going to look like this on their bills, and it's going to raise only 1.4. Is that correct?
Correct. So they'll just see where most utilities, they show one interim rate adjustment. Our customers will see interim rate facility fee adjustment and interim rate distribution adjustment. They'll just see two interim rate lines instead of one.
I got another line that's questioning, Madam Chair, but I don't know if anybody else had questions on the interim rate amount.
Doesn't look like it.
Okay. And the last one is a transportation charge. Your business model has changed in the last 15 years. You've done more bringing back the ghost of Bob Brill, who was fighting the way that you're redesigning your system. We're living with it now. You have much more transportation customers on your system. And in most cases, my understanding, Mr. Swanson, and when the big guys have transportation customers, they don't raise their rates, but we use that so that the other ratepayers aren't paying for it. It's the shareholders that eat that increase if they don't increase their interim rates on transportation. And so I didn't know how transportation played into this because it wasn't on the columns that we were dealing with. And so my question to you is, the transportation customers are you accounting for a 15% increase, or is it just everything is built into the non-transportation customers? You understand what I'm asking?
Madam Chair, Commissioner Tuma, I think we're tracking you, and Ms. Anderson can maybe dive deeper into it if necessary. But the rate case is essentially, the entire rate case is leaving the transportation customers alone. There is no increase for the transportation customers.
Nothing assigned to them on the interim rate increase.
Madam Chair, Commissioner Tuma, that's correct.
Or final.
Correct.
Or final.
Or final.
Mr. Adnesio, are you okay with that? I mean, we're
not deciding the final though now.
Huh?
No, I understand, Madam Chair, we're not deciding it, but I just wanted to make clear that.
Correct. Interim rates, typically we've had transportation, I thought was always kind of included in other people's rate cases, and we just kind of say to them, yeah, that's over here, but we give you the rate increase for that, and if the shareholders want to go after them over the next 2 years or whatever, that's kind of, they were always seem to be in the calculations. And so there was some of the costs spread over to the transportation customers, whether they went and collected it or not, that was up to the shareholders to do.
Mr. Adnesio.
Am I missing it, or?
Madam Chair, Commissioner Tuma, I had to say, I'm getting a little confused. I kind of wonder if we're conflating some of the market-based rate customers that other utilities have with just transportation-only customers that secure their own gas, but then transport.
There's a little rate. There's a rate built into that the company collects on. So.
Right, and I guess with respect to interim rates, I'm going to not weigh in. I guess as a general principle, what the company's describing was kind of not my understanding. I thought that the transportation customers mostly paid these same facility fees and distribution charges, but just then didn't pay any of the commodity costs. I could be wrong about that. I mean, I'm obviously wrong about that. That would be something we will look into during the course of the rate case then.
Well, yeah, and I guess that would be my concern is that, I know they're a separate thing they do, but it is still, and they're a benefit too, a lot of times to the rest of the ratepayers being in the rate case. But the question is, should they be in the rate case? At least I saw some information in the record about that in the filing, so I guess I'm trying to understand why they wouldn't be part of the rate case. So,
Ms. Anderson.
Thank you, Madam Chair, Commissioner Tuma. I apologize if I wasn't clear. We're not proposing any change to the transportation rates. With the way our tariff works, there are components or elements of our transportation customers are tied to rates from the underlying rate class to which they would otherwise belong. So to Mr. Adnesio's point, the transportation customers are still impacted to the extent that the underlying class to which they belong is impacted, but we're not proposing changing the additional transportation rate, right? So say a transportation customer would belong to our LS1 class. They pay rates based on LS1, that's one of the classes that's on your chart, and then they pay the transportation rate. So to the extent that their rates are based on LS1, the underlying class to which they apply, they are affected by the interim rate increase in that way. But the transportation fee itself is not, the transportation rate itself is not part of the rate class. But they're incorporated in the rate base, and they're incorporated in the interim fees by virtue of paying the fees affiliated with the underlying class to which they would otherwise belong.
And I'll trust Mr. Cherney and Mr. Agnizio will take a close look at that during the rate case so we can figure out what their fair share should be in this situation. It is a substantial increase to what they've done in their business model, and I don't know how it affects other ratepayers, whether they're being subsidized or not. That's what we do class cost of service studies for, and we've gone around on transportation, what that looks like. And I'll let you worry about that. It just jumped out to me. It wasn't clear to me whether they were part of the rate increase. You say they are, and I'll trust that they're going to be part of it, but not, that transportation fee is part of the overall business model that you're dealing with. So I'll let it play out there, and not need to, for the dollar amounts we're talking about, it's not going to be that significant.
Commissioner Sullivan.
I have a question for the company. The department and the OAG support decision option 5, requesting some more time. I'm wondering where the company stands on that.
Mr. Swanson.
Madam Chair, Commissioner Sullivan, the company's preference is not to extend. Extensions inevitably lead to more work and more cost, but the commission certainly has the statutory right to extend because you do have multiple cases in front of you. We'll work with whatever schedule the commission orders, but as I say, our preference is not.
Does the department or the OAG want to respond to that, or?
I didn't know 9 and 5 were exclusive. I thought 9 and 5 went together, but I could be wrong. That they're going to do that extension, but then we're going to give ourselves a lot. In a sense, we're not going to use all of the extension. That's the way I read 9 and 5 together, is that we're going to give you the extension, but we're going to ask for a July 11th order from the OAGA or OAH. At least that's why I understood it.
And Madam Chair, Commissioner Tuma, our preference was decision option 8.
Oh, I see. Okay.
And then just keeping to the 10-month schedule.
Okay.
Does it? I'd be interested in just hear it from the department and the OAG.
Mr. Agnizio.
Madam Chair, Commissioner Sullivan, we could probably make that work. Like I said, we had kind of mapped this out as just a little under 11 months, so it wouldn't be an enormous change, but that's, I mean, we have a lot of contested cases going on. It was not a simple exercise to get all that into a spreadsheet in a way that.
So the department, I just want to make sure I got the position correctly, is the department could make 4 and 8 work. It's not their preference, it's not your preference, but is that?
Madam Chair, Commissioner Sullivan, yes.
Okay.
Mr. Cherney.
Madam Chair, Commissioner Sullivan. The department has been working on scheduling because we've got so many rate cases and we've got the Elite merger and Prairie Island, a lot of different contested cases. So that's why our preference is for the extension. Like I said, we're looking forward to being efficient with this case, but in our minds, it just makes more sense to have the extra time, and then if we don't need it, we don't need it.
Does there, does this seem like, is this a settleable case? Is this something where people will be working towards a settlement? I mean, are the issues, do they seem intractable? I don't know if that's a fair question, but I'll ask it.
Madam Chair, Commissioner Sullivan, we certainly hope so. We don't think there's anything exotic here. The challenge is it's been 15 years. Mm-hmm. And in that time, the rate base has grown 4 times what it was last time.
What's your current ROE, Mr. Swanson? I don't remember.
The most recent approved was 10.0, which is what the company then requested again. The company, for example, did not hire an expert. That would be a significant expense to their customers.
Mr. Adamizio.
Madam Chair, I don't see any unusual obstacles, so I mean, I think this case is as settlable as any other case.
And to be fair, Mr. Swanson, I mean, I look at the difference between 8 and 9. It's 11 days. But I think to be fair to you, your concern was, yeah, it's 11 days, but it gives room for more. And so you're worried that we'll become, because we're the little guy in the room, ours becomes the least preferred thing to deal with, and all of a sudden 11 days becomes 35 days or whatever. Is that a fair rendition of what your concern is?
Madam Chair, Commissioner Tuma, you've said it more bluntly than I would have dared, yes.
Any other discussions from commissioners or someone ready to make a motion?
If you want, Madam Chair. I
Commissioner
would
Tuma?
recommend 1, confident in the words of our state agencies that I can go with 5, 7, 9, 10, all of the recommendations, 12, 13, 14, and I would say a modified 15, which would be improve the most recent proposal by GMG to apply interim rates at 15% across the board to both fixed and facility charges. I think.
Wait, sorry to interrupt, and maybe you're getting it, but if you look, 14 is approving their proposed interim cost of capital for setting interim rates,
Yeah, that's
which
just the cost
doesn't
of capital.
change even in the late filing. And then you're saying you're approving the what date?
15, what they filed, the late file 15 across the board. I'm going to look at my order writer to see if she understands what I said, because I was trying not to dictate, but. So I think I'm saying approve the most recent GMG proposal to apply interim rates as a 15% fixed percentage increase and a 15% distribution charge on all customer bills. I think I get there, but I'm dyslexic, so
what schedule is that? Should we approve what filing date or something? Is it Commissioner Tuma or Ms. Anderson?
Madam Chair, Commissioner Tuma, it is the proposal that was filed on December 2nd. And I think that what you're looking for is apply interim rates as a 15% increase to facility fees across all classes and a 15% increase to distribution charge across all classes.
Right. That's what I was trying to
As
do.
separate line items. I think that would get us
Got it.
there.
Okay, and then I would move 18. Well, actually, let's just do 17 if that's okay too. Just give us the final so everybody has the calculation. 17 was meant to be with 16, but is that okay, Ms. Anderson, if we do 17?
Madam Chair, Commissioner Tuma, I will file whatever the commission wants us to file.
Yeah,
I think that's the politically expedient answer.
let's just do the math so everybody has the math. So, and then 18, 19, all subparts, 20 and 21.
Mr. Bonnet.
Madam Chair, I know it's a little nitpicky, but decision options 11 and 12 were meant to go together.
You
I
know,
don't
I
think
had that down, and you corrected me during the briefing, and I screwed up. So,
good job.
So 11, also.
Is the motion clear for everyone? Any discussion of Commissioner Tuma's motion? Hearing none, all in favor, please say aye.
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 Opposed? The motion prevails. Thank you, everyone. And now, one more agenda item. Mr. Andringa? What, little bit louder.
You have it about right.
Andringa.
Andringa.
Please
You
introduce.
said it right in the previous agenda meetings.
Well,
No?
it's been a
No
little-
need.
That wasn't after
that was,
long.
Yeah. What happened today? But
Good afternoon, fog
welcome
starting
and
to
thank
settle
you
in.
for your work. Please introduce the item when you're ready.
No problem. Thank you. Good afternoon. Today's final agenda item is docket number G-022/MR-24-351 in the matter of Greater Minnesota Gas's petition for approval of a new base cost of gas. The question before the commission today is, should Greater Minnesota Gas's proposed new base cost of gas be approved? No additional filings made after the briefing papers are filed on November 26th. Thus, staff has no further comment, and staff and parties available for questions. Thank you.
Okay, thank you. No late filings on this one. So are there any questions from commissioners? Otherwise, it looks like the decision options would be 1 and 3. Is there any discussion from commissioners on that? Then I would move decision options 1 and 3. All those in favor, please say aye.
Aye.
Opposed? The motion prevails 5-0. Thank you very much. That's it for the day. The commission is adjourned.
Thanks for using WebEx. Visit our website